Well, you want to get going?
Let's do it.
Section 50, this is our last class, and we were talking the other night about post-judgment remedies, and we're going to finish talking about that and then talk a little bit about what the final exam will look like and how to prepare for it. But the last case we have is this aviation supply case. And it deals with the appointment of a receiver. It also dealt with this post-judgment discovery that we touched on the other night. Until such time as you obtain a judgment, you're really not generally entitled to inquire through the discovery process about assets that the defendant has. But through Rule 69, once you have obtained a judgment, you do have the ability to request discovery post-judgment in order to ascertain what assets are available to satisfy the judgment that you've obtained. And there are other post-judgment remedies. We looked at an attachment the other night, which can be both pre-judgment while the suit is pending, but it also can then be sought afterwards in a subsequent suit with a request for an attachment over the property to preserve that asset. There are various forms of attachment. The other night we just simply looked at a real estate attachment, but as we discussed, you can attach personal property, motor vehicles, boats, ships, airplanes, personal property, although personal property beyond items of significant value are generally not worth the cost of seizure and selling it. Depends on what type of asset it is, but you don't want someone's old couch. It's certainly not worth the expense of the time. Wages can be attached. Generally, again, what we're looking at is post-judgment. The court is much more likely to authorize various means to allow you to be able to satisfy that judgment than when you're in a position where you have yet to obtain a judgment and shown that that judgment is unsatisfied. So a lot of times what people do is they'll get the execution, they'll give it to the sheriff or the marshal, they'll ask the sheriff or the marshal to make demand upon the execution, which simply means it's a formal request that the sheriff goes to, whether it's a place of business or the defendant's home, and tells them they've got a judgment for X thousand dollars, and that if it's not paid within the 30 days, that the plaintiff may undertake steps of seizing assets or suit on a judgment or things like that. Sometimes then it would be paid within the 30 days, but if it's not, then we still have to look to other means post-judgment of trying to collect it, either by way of the attachments we talked about. If it's an ongoing business, you could seek what we call a keeper attachment, someone in essence standing at the store to be able to receive whatever funds come in to satisfy that judgment. If it's your wages, we would send someone, marshal or sheriff, again down to your employer, and they would serve that writ of attachment to seize your wages, that the portion of your weekly wages that would be non-exempt. Lastly, what we have here is the extraordinary remedy that we discussed the other night, which is the appointment of a receiver. And here, the defendant has refused to comply with discovery requests regarding what assets they may have. The plaintiff doesn't appear to have been able to find any other assets available to satisfy the judgment. So what they're seeking at this point is the appointment of a receiver. And the receiver, as we said the other night, has the power to take control over the corporation and to do whatever is necessary to carry out the court's orders if there are orders that the court intends to be carried out, or if in the event the receiver was appointed because there is a judgment that has been unsatisfied, to take control of the corporation and, if necessary, to actually liquidate the corporation to satisfy that judgment. It is an extraordinary remedy. It isn't done lightly. It isn't likely done pre-judgment. But now what we have is a situation where the defendant has continuously and continually refused to comply with that order of the court, which is the judgment. And at this point, and in this case, aviation, the court has decided that the appropriate remedy would be the appointment of a receiver, potentially to acquire and liquidate whatever assets that judgment debtor has. And that's precisely what the court has done here. They're arguing that, well, you know, on what basis is it? It is, as the case even says, it's an extraordinary equitable remedy, and it's only justified in extreme situations. But here we have a set of extreme situations. The defendant has done nothing to attempt to satisfy the judgment, has refused to cooperate with discovery with respect to the assets, and as the court sees it at this point, there really are few alternatives to assist the plaintiff with satisfying the judgment. And at the end of the day, the appointment of a receiver rests within the discretion of the court. So it's up to the court, as long as it's not an abuse of discretion, that order will remain in place. And here the defendant can complain about what the way they think they've been treated, but frankly, looking at the facts, you should find that there really was no other alternative that the court was left with at this point. And I've seen receivers appointed with far less of what I would call willful disobedience with the various requests by the court and the plaintiff. And the fact is that if you sit back and do nothing, or sit back and think that the day won't come where the court will take and execute an extraordinary remedy, the fact is that that's not likely to be the case. At some point, the court is going to have to, or they don't have to because it's discretionary, but the court is most likely going to allow the plaintiff to satisfy that judgment, even if it means liquidating all of the assets of the corporation and in essence extinguishing the corporation, which is precisely what would happen at the end of the day here. But they've had their choice, they had their alternative, they chose not to comply, they chose not to cooperate. At this point, the court doesn't have an alternative but to appoint that a receiver. Sometimes we've seen receivers appointed in situations where, like to desegregate the Boston Housing Authority, or to assist with the depollution efforts of Boston Harbor. Sometimes it's to carry out orders of the court. We saw it in the Republic of Philippines case. That's what they were looking to do, and then they ultimately called it a special property advisor because it was prejudgment. But that receiver has all of the authority in the world to assist the court with carrying out its orders. It's an extraordinary remedy. It displaces all the other powers that the corporation might otherwise have. Questions on that?
What's the qualifications?
Usually it's going to be a lawyer. Oftentimes, it depends. I guess if it was a really specialized business, that you might have them appoint, I could see these days some type of technology expert who has better skills and may well know what the assets are valued at and the like. But more often than not, it's going to be, in essence, an extension of the judicial system, so it's likely going to be a lawyer appointed to help the court carry out its orders. In my experience, it's almost always been a lawyer, but I could see circumstances, and I'm sure there are cases where the circumstances are, it is someone who has both business skills and perhaps skills that are unique to that business that would allow them to either be able to enhance the value of the business or to be able to find whatever assets are there. But just because whether it's that person that we just described or a lawyer appointed, that doesn't mean that they don't have the authority to bring in other people at any rate, because in both situations. So if the business technological person needs a lawyer, because they run the corporation just as the board of directors and the officers did before, they have the power to hire those people that they need to carry out. So does the lawyer. If the lawyer needs someone that needs investigators or technology experts, that person who has been appointed the receiver has the same authority, just as if they were spending their own money. At the end of the day, all of their expenditures and what they have done has to be blessed and approved by the court at the end of the process. But until that process is over, they have the full power with the court's authority to do whatever they need to run that corporation. Change the lock, you name it, it's as complete as it sounds. It ousts the existing board of directors and executives of the power to run that corporation. And so what you would do traditionally is you change the locks, you oust the people that are there, and you keep some personnel depending on the size of the business because you got to run it, but you're not going to keep people who are hostile to it because we don't need them there and they won't stay there. Questions on it? Okay, so let's talk about the final exam and the questions that have been posted online for all the online people. So all of those questions should be submitted the answers should be submitted by the close of business on next Monday when classes end. And so everyone should be up to date with that, not with what they have been required to do through the course of the semester for if you've taken the course online. Now, our exam is the first Wednesday of exam week. If you want to know what that exam is likely to look like, then look at my old exams. I think at least I know all of you who are here have had me before. My exams do not look dramatically different. The only thing I would suggest to you is, well, first, two things. Look at my old exams. There are terms that you should be thoroughly familiar with because they are, in essence, the important concepts here that we have talked about from day one that pertain to remedies, equity, concepts we've spent some time developing. You should be able to define those concepts well and then apply them to whatever the situation that you're asked to apply it to. But as I've said to you before in other classes, is those concepts are terms of art. So spend some time and really think about what those concepts are likely to be. I actually think that, like other classes, that if you sat down and made a list of 20 key terms here, you're going to have 10 of the 10 that are likely going to be on that list. So spend the time doing that. Think in advance. I don't come at you sideways. I come at you straight on, and I'm telling you that would be a very wise use of your time. It would also be a very wise use of your time not to just think about them here, but to reduce them to writing. And then look at them and see if it says precisely what you want it to say. And if it doesn't, revise it, edit it, improve it. Look at it again. Does that define it as clearly as I can so that I'm going to get all of my points here? And if it doesn't, then take a look, see what you change. Really work and edit it over so that it says precisely what you want. I don't want to have a conversation later on that, well, that's what I meant. You know what I mean. And don't be giving me examples until you got to define it. Define the concept. That's what we call the law, right? The black letter law. You need to know the law. And then look at my old exams. I think the only change you might likely see is what I have. So the format's going to be virtually identical. But what I have tried to do more recently is tailor them a little more like you're going to see on the uniform bar exam. So you'll still have a fact pattern, and you'll still have the concepts that are important. But that fact pattern may be broken down to two subsections because the uniform bar exam now are 30-minute essays, and they do direct you more. It's not sort of the rights and liabilities of the parties anymore. It's, what should the federal court do with the motion to dismiss that the plaintiff or the defendant has filed. So they direct you more to the issue, and then you've got to focus on that issue. Just don't fill up a couple pages of BS. And so I could see where, we may have to, you will have a fact pattern, and then you may have one that's a broader question, but then one that is much more pointed that could be addressed in 2 or 3 pages. And I'm almost sure that that's what it's going to look like. And so you're still going to write an essay, you're still going to write the definitions and apply them, but I think you may well see that the essay one is broken down into a 4-page or a recommended 4-page and a recommended 2-page, obviously being the smaller one being much more directed to ask you to investigate and explore whatever that issue would be. The best way to prepare for it is to look at all the stuff we've done, look at the questions that are posted online. Obviously, those are important things that I've asked people to think about from day one. and to really think about what our conversations have been about when we've been here. Because there's 15 weeks. When I structured this course, I really tried to make it so that each week is self-contained as to what I think are important issues to address that week. So you don't have an unlimited amount of concepts here. And I think if you really look and focus on what we've done, you'll have a pretty good handle on how you should be addressing it. I see remedies, at least in part, as an extension of CIPRO. So if there are issues about what court to go in and where and under what circumstances, don't blow by those issues, grab those points and talk about them. But obviously, for instance, if you're talking about injunctions, you should know a lot more about injunctions now than before. You should know a lot more about the details of the injunction, the process for seeking it, the eligibility for a hearing, what type of hearing that would be, what the bonding requirements might likely be required, what that bond is for, and what happens if you violate it. Equitable remedies is what the course is called in a lot of places and traditionally. And for the most part, that deals a lot with injunctions and the like. So don't, obviously your focus and a great deal of your attention should be thinking about that whole process. And not just thinking about it, but think about it in detail, because I think we probably spent about 4 weeks on looking at the intricacies of that process and what that would entail with respect to the protections we're entitled to get. So don't give me a couple sentences if that's somewhere in there, because there's a lot of material that you know now or should know if you go back over some of your notes and think about it in a lot more detail than you might have when you started the course. You shouldn't have concerns. I don't write a time-sensitive test. I don't want, the brain dump. What I want are answers directed to the questions that I've asked. And I don't want you to feel like you've got to just write everything for 3 hours and then hopefully you'll hit it. I want wisdom. I want you to really think about the question and the answer, and you should have plenty of time. And my guess is the likelihood is most people will be done before time ever gets called. I would think it's probably going to be 2.5 hours comfortably. So don't, if you're the type to freak out about, oh my God, am I going to have enough time? You should be okay. Some will be at the end, sit there with me at the end, but you should be relatively comfortable on time. I don't care for the ones where you've got 8 pages to read and it's going to take you 6 hours, half your time just to read the exam before you even can think about what the right law is. That doesn't necessarily make a lot of sense to me. Who's got questions?
Is IRAC a big thing?
Yeah, you know what? In this conversation has come up a lot. I always think the whole idea about IRAC is just good writing. It's because I did this when my kids were taking the SATs. They had brought in the writing sample. They were finally going to take it. I said, well, so how are they going to attack that? So I started looking at it, and and I'm just going to use it as an example. The paragraph should have because you're supposed to write they were looking for 1 or 2 paragraphs. Strong thesis statement. Well, isn't that the isn't that issue, right? And so then you should talk about what the authorities are that would support that thesis. Well, isn't that the rule, right? Is that the rule of law? And then they said, well, then you take the authorities and apply it to your thesis. Well, isn't that the application? And then the C is conclusion. Well, every good paper should conclude with what it is you were looking for, right? So and that's good writing, right? And so that's the whole thing is people get hung up on whether it's crack or IRAC or what do I use? ICRAC. We can have a whole bunch of different mnemonics, but what it really says is to think about what it is that's being addressed. What do you want to say? What's your point, right? Support your point. Make your application with the rule, because that's how you're supporting it. and then conclude, one way or the other, where are you at? And that's good writing, and that's why, to me, some of this sometimes, I don't, if you just give me a page that says Plaintiff wins, how'd you get there? I have a math background. I like to see how you got there. And so talk to me, and again, our business, I got one now. I hope I'm right, but it's this way. It could go my way, it could go their way. It's going to be a close call, and it's we're just beginning, so we're just barely into it. But if you ask me to write a paper right now, we're going to write a motion to dismiss on it. But I think it's clearly consistent with Rule 11. I wouldn't be filing it otherwise. If I were writing that as a law student, I'd talk about, well, what are the arguments against the motion to dismiss? And you could write a pretty good argument there. So as a lawyer, we don't just take a position without recognizing what the likely avenue of attack is. Because if we have to recognize that and talk about how we might dismiss it. So weigh in on what the issues that you see, and don't just sort of blink away problems there. If you think there's something issue there, you should address it, because a lot of it is just recognizing how this would all go down. You have arguments, but so does the other side. Somewhere, hopefully, way down the road, we'll figure that out. But that, there will be issues on both sides of the fact patterns that, if depending on who you represent, you could make good cases for each. So if you've made a decision that you think it's likely subject to attack, or made at least a preliminary argument that you think is likely to attack, talk about, this is not without its problems. I expect the defendant, or I expect the plaintiff to say X, Y, or Z, because under the law, blah, 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 blah. But, I think we're on solid footing here and should have the stronger argument. That's fair to say. And I think that's probably likely. It's likely in the real world, and it's likely going to be what you probably will see on your question. So what else you got?
Any civ pro concepts like SPV?
Yeah, I don't expect 5 pages of SPV, but I think, this remedies deals with litigation, so you're going to have to figure out, or you may have to figure out what court, where. It won't be terribly involved, but I wouldn't leave those points on the board. Hopefully you should have remembered that, and you should be able to do something with that. But yeah, that's a legitimate issue when we have a real, and that's the thing, what I've tried to do with this class is you're sort of making the bridge between law student to lawyer. And so in the real world, those SPV issues, that's what we got to decide all the time. So where are we going to go? Where do I think we have a better advantage? What are my alternatives, and what looks best? And so, if you have a question on that, so a couple paragraphs, then that makes sense. Plus, part of it is, remember, if it deals with other issues about equitable relief and things like that, not every court can grant that. So don't be telling me you're going to the Massachusetts District Court for much equitable relief, because you're wrong. Bad place to go and wrong place to go. Federal court, Superior Court, they have the broadest powers in that regard.
Wouldn't you say the same for Rule 11?
I think Rule 11, listen, we spent a fair amount of time talking about moral and legal issues, and I think that's important for you to recognize, period, because the judges want to know you know it, I want to know you know it. And it is something, honestly, again, this case that we're getting ready to file a motion on, I was thinking, still thinking that I should send a notice out that if we're successful in dismissing it, that we may well be seeking Rule 11 sanctions. And so, again, that's one of those things that should be in our minds all the time, because it's what the court expects of us, But it's also, to me, what we should expect of ourselves. It just requires you to think a little harder about dotting your I's and crossing your T's and making sure you feel you're on relatively safe ground. Questions?
Think we're good?
Go ahead.
Can you give us a sample question how you would want it answered?
No, I don't like, you've got sample questions. There's tons of questions downstairs at the library desk as well as online. I'm not going to give you an answer. There may be answers out there somewhere from other years and the like, but I'm not going to give you an answer as to how I would answer it because then I've done most of your work. I want to know how you would answer it, having done the work from the class throughout. So there's your answer.
I think I can't believe, but are we gonna have like multiple choice?
No, I don't. I'm not going to have multiple choice. But by the way, I mean, I think you guys know now, Civ Pro is part of the multi-state exam, which means that you will see Civ Pro multi-state questions on MBE now, but it won't be part of this.
Weren't they before?
No. Traditionally, it's only 6 subjects. Civ Pro was added, I think, 2 years ago.
Oh.
So, relatively new. Well, you want to see some multiple choice, do you?
No, we're good. Yeah, I'm good.
No, I like the format I've got. I think it works pretty well.
I would like to see it, but I'm not opposed to it.
Okay. I think they'd vote you down, right? Just so you know.
The only reason those questions are tricky as hell, and I think exposure to those.
Well, you're going to have plenty of exposure, okay? But I do hear you, and that's part of the idea. Is the more you are exposed and looking at them and thinking of them, and recognizing someone. I shouldn't say. I'm going to tell you. Someone brought me an evidence question earlier today. And they said they gave it to Professor Capani, and he got it wrong too. But it wasn't that difficult of a question. What it did require was a very careful reading. And most of the multiple choice questions do. It was an offer of compromise mixed with this offer to pay meds. So what it was really an offer to pay meds, but it included that you must have a release as well. So I'll pay your medical expenses if you promise not to sue me and sign this release. Well, that's an offer to compromise masquerading as an offer to pay meds. So they know you should know the distinction now. And so you jump quickly and say, nope, the offer to pay meds is out, but all the other statement comes in. That's wrong because what you haven't applied it correctly to the facts here. This settlement offer is an offer to pay meds. And because of that, it's an offer to compromise the entire claim. All of it is excludable under the circumstances. And even if you knew the law well and understood the distinction, if you don't read the question carefully, then you end up getting it wrong because you think you know more than you do. And so that's I think one of the big keys is you got to really read it carefully and really try to think about each line of that question. And then obviously you got to know the law well and apply it carefully. But a lot of those, the most important part is to read the question very carefully because the sad thing is they're attempting to trick you. It's like a question like that. I've seen them enough that that is one of their tricks is they have an offer to compromise masquerading as an offer to pay meds. It's what they do, and it seems crappy to you probably, but when you've seen it, this is one of the things they do. So the more your point is, my point is, the more you're exposed to it, the more you can sort of say, I sort of get what they're doing here, and so it's a good thing overall.
So we'll be there on Thursday for the mini bar, it seems.
Oh, I don't know whether that I don't know whether that one will. No, this Zach was studying for the comp test, and he showed me the question. And, All I had to do was highlight 2 lines because I knew how they got it wrong. But you gotta be careful when you're doing that because, and they have a couple of others like that. So hopefully that's the other part of it. The more we do expose you to it, the more you start to get into it with comp. There are things like that that you can avoid long-term. Obviously not. I taught Zach evidence and I taught it to him in comp and he still got it wrong. No, he's a good student. I'm just saying, you can't let them you can't, and that's the other thing. At some point, you do get confident, you get comfortable, and that's where you still got to be careful. Because that's especially when you got to be careful. You let your guard down, you say, oh, okay, I got this now. Not necessarily. So, what else we got? We all good? So Ray's test will have 10 multiple choice and everyone else will be good? Okay. That works. That works for all of you? Okay. Listen, good luck. I'll see you. I'll be around, obviously. I actually won't be around the first part of next week. So if you've got questions, next week's reading week. So I won't be around the first part of next week, but the end of the week I will, and the following week I will. So if you've got questions, I'll be around.
Happy belated birthday.
Thank you. Thank you very much.
Monday, right?